As introduced, my name is Linda Boren, the International Criminal Justice Lawyer at the Wayamo Foundation. It is indeed my pleasure to be moderating this panel of very distinguished guests. It's my pleasure to have you all on this panel, and I look forward to moderating it. And we will be talking about transitional justice in an ever-changing world. That's the topic of the symposium today. But we have to look at also how is transitional justice changing. And each time we talk about this ever-changing world, things that are changing, we often think about technology. We think about mobile phones. Back in the day, we had this, the Nokia phone that, was very basic. Now we have smartphones, and now we're in the world of ChatGPT and AI, I think for universities, this is something that they must be grappling with as well. This morning, as we were coming, Kojo was lamenting to me about how he wasn't able to get a newspaper at the hotel shop. And again, this is another change, how we consume information and how, quickly we are informed about things. Many people now turn to their mobile phones. In the case of Sudan, we were basically informed as soon as the first shots went off. We were all able to follow what was happening with the conflict, the violations that are being committed there, the suffering that the civilians are going through, and the difficulties that many people have faced trying to get their way out of the country, trying to get their families to safety. Now, when we look at all of this, these human rights violations that are being committed, this is where transitional justice comes in. It comes in to deal with these violations. It comes in to address this legacy of violations that are committed. However, is transitional justice suited to ongoing conflicts? This is one of the questions that we are going to be discussing today with this panel. We are also going to look at the history of transitional justice. How have things changed? How has it evolved? Its history is based on the post-World War order, when we had the establishment of the United Nations and the famous words, never again. Since then, we've had the establishment of tribunals such as the Nuremberg Tribunal, the Tokyo Tribunals. In the 80s and 90s, many states that had been under authoritarian regimes established Truth and Reconciliation Commissions to try and deal with this legacy of abuses that had been committed under these regimes. And we have one of the eminent people who was involved in the apartheid struggle here, Navi Pillay, and people who've been involved in the Truth and Reconciliation Commission for South Africa and trying to deal with this legacy of abuses that had continued in their country for several years. Now, in the 90s, we also had the establishment of the ad hoc tribunals. We had the International Criminal Tribunal for the former Yugoslavia. We also had the International Criminal Tribunal for Rwanda. And this morning, we have with us Serge Bamats. He's going to talk to us about the contribution of these tribunals to transitional justice. And he is the Prosecutor Under Secretary General of the United Nations International Residual Mechanism for Criminal Tribunals. But one of the questions that we're going to be asking and grappling with is, were these tribunals really suited to dealing with this legacy of violations that were committed? Were there other things that could have been done better? We are also going to be looking at victims and the role of victims. I think one of the things that we could argue about is that in traditional trials, victims tend to play a very limited role, mainly as witnesses, and they don't really get the opportunity to express themselves, express what has happened to them fully. Now, they also have a right to a remedy. They have a right to receive reparations. And we have with us Michael Delagrange. He's going to be talking about this topic. He's going to be looking at reparations for victims and what are the rights that victims, what are some of the rights that victims get in times of conflict. And again, talking about ongoing conflict, are there some of the things that we could be looking at and thinking about even from the earliest stages, not just in post-conflict environments or post-authoritarian environments? Then I had started by talking about never again, and this is one of the concepts of transitional justice, non-recurrence. We talk about prevention. How do we prevent this type of things happening again in our societies? But then we continue to see this. And Aishatu Mindaudu, she's going to be talking about this concept of non-recurrence and how societies deal with this legacy, not only from a criminal law perspective, but also looking at it in terms of institutional reforms. How do we return or foster this environment of the respect of rule of law? So these are some of the things she's going to be talking about during this panel. But last but not least, and he'll be starting us off with this panel, is Christopher Gitari. He is the Senior Transitional Justice Advisor at the Joint Monitoring and Evaluation Commission in South Sudan, and he has experience from different countries on the African continent with transitional justice. So he's the one who's going to start us off, situate us in this discussion, and talk about all the different evolutions that we've had. So you have the floor. You begin. You have 10 minutes. I've been instructed by Bettina, and as she said, she's very strict, that I have to be extremely strict. So you only have 10 minutes for your intervention, and then the next speaker will come up after you. Thank you very much.
Linda, thank you very much. And to my fellow panelists, good morning. All protocols observed. Where we come from, where I'm working currently, we say all protocols that have come. I mean, it's a light joke. My name is Chris Gitari. I work on transitional justice in South Sudan. I'm very happy to be here. And 10 minutes, that's quite a task. I'll try my best. To start us off, just to say we are deeply in the third phase of transitional justice in terms of how we see it evolve. Recalling the first phase being the post-World War II, where we had the Nuremberg trials and the Tokyo trials, where international criminal justice really came out as a tool to bring accountability. And then we went into the second phase, which is really the end of the Cold War era. And here we see the ending of the juntas in the Latin American area and the preference for local, national types of justice approaches and the rise of the truth commissions. That was the second phase, and you can then see the tensions between peace and justice really emerge in that period. And then we get into the third phase, which we are deeply in, and sometimes I think we are at the end of it, really where there's the permanency of transitional justice mechanisms, and the poster child being the International Criminal Court, where we say we wanted an international criminal court that is permanent, that would be taking many of these cases where countries are feeling they are unable or unwilling to prosecute. And in this context, Linda just painted the picture of the rise of artificial intelligence. And also, I would say there are other externalities in Sudan, the externalities of the Ukraine war on it in terms of its TJ processes and what that looked like and what that currently looks like. We see the move from a bipolar to multipolar world. And what does that mean for us? Here domestically, the South is getting poorer. The tensions between the North and the South, where the money is in the North, the experiences are in the South. What are those tensions like, where there's less money in the South to pursue TJ? That's a big tension that we need to think about. There have also been other trends, positive trends such as the inclusion of victims in designing TJ mechanisms. We see victims being the source of energy, as President Santos in Colombia would say. What gave him the strength to continue with the Colombian process is giving victims time to give them and share their experiences, and that became one of the drivers. When the TJ processes are done, like the experiences in South Africa of the Hulumani, they are the ones who continue with the legacy of pushing for accountability. We also see new emerging concepts. Really, one that has taken root is one of the role of women in also participating in TJ processes, quite understated, but played out quite rigorously in Sierra Leone, where really we saw women being at the forefront in both participating and designing TJ processes. And then we have also seen a conversation, and where really there's really lack of capacity, particularly in South Sudan and in DRC, really the use of military tribunals to try to fill and close the gap, imperfect as it may seem, but we've seen them being used to try to rein in really reckless militias and soldiers. We've also seen the rise of conditional amnesties. That has been for a while. There was a sense in which that should be discarded, but it's re-emerging. It did emerge quite strongly in South Africa. It had been there in terms of de facto type of amnesty in the Latin American experiences. In South Africa, we saw it come as conditional. We see it being fought, but now we see it emerging. And we also see the issues of resentencing procedures and conditional pardons in Colombia. We are seeing a distinction between punishment and accountability, and they try to have that divide where you say, we can hold you accountable, but the punishment is different. The sentencing procedures are light. For instances of murder, we see people doing community service. But we also see in those contexts a conversation around how to rehumanize perpetrators. There are huge conversations beyond the victim participation and engagement with victims. We see efforts, and in Colombia is a good example, where there's an attempt to have perpetrators adopt the perspective of the victim. So out of retraining or re-engagement with perpetrators, so that eventually they can come before victims and say that really they acknowledge their harm. And somebody just mentioned it just here earlier, the earlier speaker on Sudan, where the idea that a community should and can, or maybe can is better, see that some of violations are being undertaken in their name and need to acknowledge that victimhood is a task. In South Sudan, it is a task where we have ethnic divisions and the acknowledgement or the lack of it that another community was violated in their name. And that is balanced off with this tension of when we are discussing a truth commission in South Sudan, those who we speak to say, are you ready to hear my truth? And it's a very poignant point that we are seeing. We also see, and sorry, I'm really just trying to draw outlines, but you can see how deep this conversation can go. We're also seeing TJ processes being repeated, where you find that a country feels that a process did not go substantially the way they wanted, and that there were groups that were left out, and you see it return. In Chile, we've seen a truth commission, I think 2-3 truth commissions, especially, for example, in Chile, where we had the victims of torture who felt they were left out, and therefore another truth commission had to be established for that to happen again. So we should not be surprised to see TJ mechanisms that were there earlier imperfect and being repeated again because there was a lack of satisfaction. So now globally, we are seeing the emergence, positively, of the right to truth. We've always had the right to information. You're very familiar with that. But the right to truth is emerging from the right to information. And that is a new concept that is now being affirmed by our courts. We are also seeing a conversation about what transitional justice is, the concept of transitional justice. We've always marked it with a transition of governments, but we are realizing that transitions begin earlier before the governments have changed and continue beyond these governments that run transitional justice processes have left. So the dislocation of the concept of transitional justice from it being in governments to it being actually windows of opportunity to change. And that's been very interesting, in my view. We are also having long conversations now around, and in South Sudan it's really emerging, around environmental degradation and transitional justice. And really we are seeing how in transnational corporations who are polluting the environment and resulting in serious violations, what that looks like and how do we hold them to account. And then that is being linked also to complicity by transnational corporations, where we've seen, for example, in Sweden, the Lundin oil company, the executives being prosecuted now by the Swedish prosecution authorities because they sponsored militia to displace people in various oil fields in Unity State. And that has been very interesting in terms of how transnational corporations are. Going forward, we should expect strong conversations, and that's emerging in South Sudan, on traditional and indigenous justice processes and how they link with transitional justice. It's a difficult conversation. It requires a little bit more thought, because the communities that fight with each other usually are not. Traditional justice processes are good with homogeneity, where you all are of the same group. For example, in Uganda, the Acholi and the Matoput process. But then you see that the communities that fight each other don't share the same local indigenous. So we have to come up with what we call people-to-people peace processes, where you involve everybody under one roof, big tent approach. But then you will still try to incorporate your traditional systems. So in South Sudan, we have the famous Woundlit Conference, where we slaughtered the bull called Mabior, as to mark, it's a white bull, to mark the acceptance at the end of conflict. And by the way the bull was slaughtered, it struggled so much. And so we said, the bull, as the way it struggled, so we shall struggle with our peace processes. We also will see, I'm almost done, right? Okay. So I think, yes, let me end by saying this. These experiences now emerge in the Africa Union Transitional Justice Policy. And I urge you to look at it. It's really what guides us in terms of how we can drive our TJ processes on the continent. And by the way, it's a policy that has benefited from global actors' influence. And therefore, there are various principles, as I end, in terms of what is emerging as the key minimum standards that we need to be looking at when we're driving transitional justice. One of them is African leadership. That African leaders need to be involved. And we just sat through 4 days of transitional justice conversations with the leadership in South Sudan. The president, the vice president, the cabinet ministers, the governors sat through 4 days listening to us blabber. And really the impact was there, that they sat in and listened and understood that they are the ones who should own these processes. The second principle being local ownership, that the locals are the ones that would and should draft their processes, of course with input from experts if they can, and drive those processes. I think the third is definitely inclusion. It's being a conversation about, and is understated, internally displaced persons and refugees. How can they, as an example, be included, people from the margins, and the invisible people? And then there's, of course, the conversation of intersectionality, where you find that you can be a woman of a particular ethnic group, of a particular class, having suffered a particular violation. You can see how far down the rungs you go. So that has become very interesting of ensuring that happens. And now I would like to stop there and continue the conversation as we ask questions. Thank you very much.
Thank you very much, Chris, for those points that you've made. Very, very... Yeah. So without further ado, let me hand over to the next speaker. We'll have Serge Bramats. He's the Prosecutor Under Secretary General, United Nations International Residual Mechanism. Thank you, Serge.
Thank you. Good morning, everyone. Happy to see so many friends and colleagues. And I very much hope that this is just the start of a much longer debate on a very important issue. Now, we're going immediately into the topic of transitional justice, where it was already mentioned that, well, there's no one fix-it-all solution, but everything has already been done before. So it's about finding a tailor-made solution in relation to a specific situation, because the situation of each country which has to go into transitional justice is different after a conflict. Or the perpetrators are still in power, or you have a new regime in place. Sometimes you have still a judicial infrastructure, but very often it is destroyed. Do you have the necessary expertise in the country or not? That's why I think, based on our experience, that you always need an international component if you want to have a successful transitional process. It can be an international tribunal, it can be a hybrid tribunal, it can be a mechanism, it can be an investigation commission, it can be a number of experts. But I think it's extremely important because, based on our experience, is that countries, especially after a long conflict, don't have the expertise and infrastructure to do it by their own, and help is needed. And it's also important in terms of acceptance of the results coming out of the process in relation to independence, impartiality seen from outside. Now I want to say a few words in relation to the international tribunals. Obviously, our experience, and I could speak during hours and hours, but I have only 8 minutes left, right? And we know that all those transitional mechanism projects have often a priority on accountability, but sometimes more priority on reconciliation, or mixing both, which is also a point you need to agree on at the beginning. And I would say the only good approach is to have both included in the process, because if at the end of the day the idea is not only after mass atrocities to look for accountability, but to make sure that the society finds through reconciliation a way to move forward and to accept the reality of the accountability process. Now, the two ad hoc tribunals, where I'm in charge of their residual functions for the former Yugoslavia and Rwanda, have together prosecuted more than 250 individuals, which sounds a lot. Those were those who bear the greatest responsibility for the crimes committed. We are now almost 30 years later, and we are still in the last trials. Just to say that, you have all learned students that justice delayed is justice denied. Well, if you speak about transitional justice, if you speak about international justice, time is an extremely important factor. Those who are in power today cannot perhaps be prosecuted, but the situation can be different tomorrow. So sometimes as prosecutors, you have to wait until there is the right moment. And what we have learned is that if now 30 years later, after having prosecuted so many individuals, more than other international tribunals together, well, fact is that I was in Kigali 2 weeks ago. There are still 1,246 fugitives at large. I will be in a few weeks again in Sarajevo. There are still 3,000 individuals under investigation. And one of our lessons learned is definitely that if you want really to have a long-term impact, you need a comprehensive approach where you make sure that not only those who are the most responsible are prosecuted, but also the physical perpetrators, if possible, domestically. Because what we see, and I'm sure colleagues will speak about it in relation to the feeling of victims, you cannot achieve reconciliation if you only prosecute the big guys, if the woman working in her village still sees the guy who has raped her. So what I think is extremely important for any transitional process is to have a comprehensive approach, international component, national, regional. And I just want to say a few words in relation to the two tribunals I'm in charge of, Rwanda and former Yugoslavia. For Rwanda, well, I will not go into the conflict. You all know that within 100 days, close to 1 million people were killed, more than 200,000 women raped. When the new government took over, no infrastructure in place, very little expertise on the ground, and that's why the Security Council put in place the ad hoc tribunal for Rwanda, which, as I said, has prosecuted or indicted more than 90 individuals. But there were 10,000 and 10,000 of people in detention. So the government, a few years after the genocide, really put a new national legislation in place, which put a lot of emphasis on confession of crimes committed, which really had as a result that more than 10,000 cases could be processed at the national level, and the main focus was the guilty plea. If you have at a certain moment there were 100,000 persons in detention, how are you dealing with this as a national authority? So by putting this system, the guilty plea system in place, and by having different level of categories of crimes, those who were among the planners of the genocide, for them guilty plea was not possible, a full trial was necessary. But for other categories, I will not go into details about them, guilty plea was a possibility with much lower sentences. But still, after 10 years of those national proceedings, it was still extremely difficult, and that's why the gacaca courts were put in place. You have heard of them. It was, in fact, reactivating community-based traditional system which existed prior to the colonial power, where the community, the villages, had a very important role to play. And more than 1,200 of those local community-based tribunals were created, where judges were elected, and where also people confessing and admitting their responsibility very often would not even receive a sanction and could go home after already having spent a lot of time in prison. Now, none of those systems were perfect, but the point I want to make is it needed to be comprehensive. And if you put a focus on reconciliation, forgiveness is very, very important. And this forgiveness can, of course, only come from the victims' community. That's why, personally, I really thought that it was the best way to go in light of the huge number of persons. And as I said, when the gacaca court started, there were something like 89,000 persons in detention. But when the gacaca courts and trials started, at the end of the day, 1 million persons went before those gacaca courts because they were community-based and people had to confess. They were also mentioning the names of their co-perpetrators, which also then were brought before those gacaca courts. So just to say that in relation to the Rwanda, I think that the different levels of accountability mechanism, with still a strong focus on reconciliation, makes that today, I think it is one of those countries where the reconciliation process has been the most efficient. Now, if I look at the former Yugoslavia, again, I could, how many minutes left? 2 minutes. Well, I could mention a lot of aspects, but I will take just 2-3 examples in a different area. Now, the conflict is a very, very different one. As you know, there were several countries involved in the conflict, which is also a different concept, where today there are still, as I said, many thousands of investigations still ongoing, and where we have to recognize today that the reconciliation part has been very unsuccessful. And that's why I agree with what we discussed earlier, that having outreach, having communication, having media playing a very important role, because the majority of our convicted war criminals in The Hague for crimes committed in the former Yugoslavia are considered as national heroes. Glorification is absolutely normal. There are 250 big signs on walls about General Mladic on walls in Serbia, despite the fact that he has been convicted for genocide. So just to say that while there have been 161 persons indicted, which is very important, and a lot of successes also in terms of jurisprudence, well, if at the end of the day a society is not really accepting, or a large part of society not accepting, you have a problem. And here I just wanted to mention 2 very specific issues which have been used and which potentially can and should be used in other parts of the world as well, was that in the early days we were doing a vetting process. For example, when after the war, especially in Bosnia-Herzegovina, and new structures were put in place, a vetting process would be in place in relation to police officers, because many police officers had been involved in committing crimes together with the military. And this vetting process was really that every person who in the new transitional government at the lower police level or senior level would get a function would have to go through a vetting process, which was in principle done locally by international lawyers, but which de facto was done by the ICTY, by the Yugoslav Tribunal, where persons to be appointed, the names were communicated to those who had collected all the information, and if you had been involved in any human rights violations, you could not be appointed, which we think was one of the key elements and which should be respected somewhere else. Second aspect, because as I said, after the Dayton Agreement, which ended the war in Bosnia-Herzegovina, Serbs were occupying or received one part, Republika Srpska, and the Croatian and Bosnians, the Federation. But de facto, even if it was one country, there was de facto an informal border, and there had been cases where, for example, militaries or former generals from Republika Srpska would by mistake cross the border into Bosnia-Herzegovina, into the Bosnian part, would be arrested, creating a lot of political problems. And therefore, a system was put in place also to do vetting of investigations and prosecutions. So when, to avoid that those kind of arbitrary arrest would take place, the system would be in place that the case file would need to be sent to the ICTY, and the ICTY prosecutors would look at it to say, yes, there is a prima facie case, you can proceed, or there's really no evidence. So a kind of support from outside before being able to start investigations. Wish you good afternoon. This 10 minutes is indeed very, very, very short to say something meaningful, but thanks for your attention.
It's appropriate that my comments should follow in the wake of Prosecutor Bramett. I feel like I've been following in the wake of international criminal prosecutors my whole career. I'm here to talk to you about the concept of reparations and why reparations are centrally important, in my experience, to the concept of justice. Now, what are reparations? A reparation is just malipo. If you look at the etymology of the word reparations, the idea is tied to the concept of repair, right? There are different types of reparations. There's compensation, of course, but there's also restitution, this idea of putting persons back into the positions that they were in before the crimes were committed. There's also ideas of rehabilitation, whether it be physical or psychological. There's this notion of satisfaction. Satisfaction is a broad term also, all within the umbrella of reparations. It can be public apologies, it can be memorialization. And then there are guarantees of non-repetition, right? These are all types of reparations. In my career, I worked at the International Criminal Court for 12 years. I worked in Kenya, I worked in Congo, I worked in Uganda, I worked in Republic of Georgia, and lastly, I worked in Sudan. I tended to be, as I was working on victims' participation issues and reparations, I tended to be one of the first persons on the ground, but more importantly, one of the last ones to leave. I brought a unique perspective to the concept of justice, particularly at the international level. And if I learned one thing, and one thing only, is that there is no justice without reparations. In the context of Sudan, together with my brother Guja, who you met earlier, we spent a lot of time with the affected community in Darfur. They have, for 20 years, been holding fast to the concept of justice. But what is their notion of justice? Is it merely retribution? Is it merely a criminal trial? It's part of it. They have 5 demands that they've held to for 20 years. First one, they want accountability. They want trials. They want criminal trials for the people who committed the crimes against them. It's important. Number 1. But there are 4 more. The next one. These people have been living with nearly 1 million people in IDP camps for 20 years. They remain there today. They don't want to stay there. They don't want to make this a permanent home. They want to go home. And that's number 2. They want to return home. Number 3. Is it safe to return home? They needed and they demanded that the militias surrounding their homes be disarmed. So that demand number 4, there's a guarantee of non-repetition. Because they don't want to just leave the IDP camps and then the next day have to return, right? And then the 5th and final demand is that once they get home, they need a little bit of support to get their lives back online, right? Whether it be infrastructural, schools, hospitals, roads, these things have fallen obviously into disrepair after 20 years. Or other means of income generating support so that they can, again, pick up where they left off, right? In my experience, international criminal justice has been myopically focused on retribution. It's not for no reason. I think a lot of the international criminal justice mechanisms, the ones that I've worked at, have a common law-based notion of the role of a prosecutor and the role of a trial, the role of an institution like these. In the domestic setting, prosecutors are charged with following the evidence and securing convictions. They do so quite generally because they are pursuing the public good, right? The international level, even though there's a lot of rhetoric discussing about the interests of victims and these being victim-centered approaches, and I don't discount that. I know prosecutors are definitely motivated by the plight of victims. But they're also motivated by international policy, right? The notion that international crimes are crimes that affect all of humanity. So there is an objective here from an international perspective to pursue them, regardless of the individual interests of victims. We miss something here. We miss something here when we look at justice in this very focused way and not in a holistic way. I can tell you with firsthand experience that when you explain to a victim community that you're here to pursue accountability in the courtroom, but that these other issues, these issues of returning home, these issues of repairing the harm that these crimes have resulted in, are left to you, left to the domestic system, or left to some other kind of hypothetical thing that will come in the future, there is a great deal of disappointment. And I think, from my perspective, this is what we need to work on. We cannot be satisfied with justice as merely retribution. I know it's hard. I know it's complicated. But there are things that can be done. I personally am a big believer in domestic accountability. I think that's going to be the future, right? I think, as we've heard quite from these passionate speeches that we heard earlier, you are the driver of your own future. There's a lot of support to come your way if you want to make these things happen. With respect to domestic accountability, I can tell you that part of our strategy in Sudan was to use findings from these international processes and bring simple claims in property law to try to get these people back home. Use these factual findings that come from these international criminal trials and then bring them into these domestic courts and show that these people were wrongfully removed from their land, that these processes have been deliberated for years, and the result was that these individuals were rightfully on their land and were wrongfully removed, and that these judges, these domestic judges, could just issue injunctive relief and allow these individuals to return home. Imagine the symbolic power. Now you might say, wow, but how would it be reinforced? How would it be enforced? And who's going to guarantee non-repetition? You have to start somewhere. Get that motivation, get that momentum going where someone says, oh, you have a right to return. Domestic judge issuing these victims this injunctive relief saying, this was your land, you have the right to return. Then the journalists of the room, we call on you. Let's make that decision something that's profound, something that moves people domestically, something that creates space for political resolution, not just legal, right? I just want to leave you with this idea that retribution and repair, no justice without reparations, right?
Thank you, Michael. I'd now like to hand over the floor to Aisha Mindaudu. She's the former United Nations Special Representative in Cote d'Ivoire, former Acting Joint UN-AU Special Representative in Darfur, and former Minister of Foreign Affairs in Niger. Thank you so much. Welcome.
Good morning, everyone, dear colleagues, friends, and everyone in the room. So as a diplomat, I'm not going to repeat the formula, but good morning to everyone. I have listened to the others intervenants that spoke before me, and I realized that I'm the only one who has almost no relation with ICC. I'm the only one. But I'm bringing here, I think, the experiences I had on the field with the implementation of transitional justice processes. But before giving the 2 or 3 comments I want to give, I would like to tell you how sad I am today. When the problems began in Darfur, following it as everyone through the media, I was quite disappointed. And why? Because I spent 3 years in Darfur. I was part of the process of the mediation between the government at that time and the Justice and Equality movement in Doha. That process took 2 years and a half, and it ended up by a document called Doha Document for Peace in Darfur, DDPD. The DDPD was signed exactly on the 14th of July 2011. So this was a kind of transitional justice process that was issued from negotiation, very harsh negotiation between the government and the rebels. So UNAMID, because I was in UNAMID was in charge of one is on. Yes, I'm saying it's the one in the middle. The one in the middle. No, it's okay. All right, so it's okay. So I was saying that the UNAMID was in charge of implementing the DDPD. And why I'm saying that institutions are very important is this morning Zainab said it very clearly. You must have at least a beginning of institutions, even though those institutions you do not have that much confidence in them, but at least you have a beginning. And at that moment, we negotiated with the government of al-Bashir, and they agreed to implement a lot of the provision of the document. They went up till appointing a Darfuri vice president. And on the field, we were working with those IDPs and with at the community level to implement and to further the process. So I'm sad and devastated today because I heard Guja talking from Darfur. Those areas I visited, Blue Nile, South Kordofan, Darfur, El Janina, spending nights there, talking with people. So I have the feeling that everything went to square one. We spent a lot of time working, and really when I left Darfur, I left with hope, telling myself that at least something has moved. But now everything got back. So I was even telling myself asking myself if it is relevant to speak about this experience in Darfur. But as it has been said, the transitional justice process is a kind of bespoke strategy, and it is different from a country to another. And still, as we have our brothers from Sudan in the room, in any case, you would have to build on the past experience, even though it has stopped. But I think that at one moment, you should really, the arms should be quiet, and then the process of discussion must come back. So, for me, he spoke about reparation and victims. For me, really, for any transitional justice process to be effective, it must be victim-centered. It must be victim-centered. Why victim-centered? Because you cannot think in the place of the victims. I have a friend who said that you cannot know better than Demba what Demba needs. Demba is a name in West Africa. So why I'm saying that? Because talking with those women in El Janina precisely, we went to see the victim, those IDPs, and you could be surprised. The ladies, when we spoke with them, we asked them what is most relevant for them. So let's get me wrong. We all agree on the necessity to pursue the perpetrators. But as you know, trials take time sometimes. So we met with those women. We asked them, what is the most important for them? So they told us, for us, the most important is that what happened to us shouldn't happen to our girls. And we asked them, how do you think that this can happen? They said, bring water close to us, because it is because they are going far from the village to fetch water that they can be attacked. So we, through those who are aware of the peacekeeping missions activity, through quick impact projects, we built, we brought them water. It is important that the process is a process, bottom-up process. So the second comment I want to make is that this issue of SCA, sexual exploitation and abuse, is never on the top of agenda of the peace processes. Why? Because women are not at the present at the track one of the negotiation. Zainab, they fought to be there, but it is not in any country that women will fight to be there. During those negotiations on the mediation in Doha for Darfur, there were quite no women on both sides of the government and the rebels group. We included them once back in Darfur. So it is important that the SCA is a key agenda in all the processes. 1 minute. So the last thing I would like to say is the early reparation is crucial. Reparation, yes, but early reparation. You shouldn't be waiting for the trials to be completed to say that you will give reparation. And the example is Côte d'Ivoire. Why? Because Côte d'Ivoire had very strong institution before the conflicts. So when the peace returned, you had still institutions standing. So they decided not to wait for the trials. They appointed a special investigation commission that is national. They conducted the interviews and they made the list of the victim. And immediately each one of the victim on the list got reparation. and it was a kind of contribution to appease the climate, and then for people to at least have some peace of mind. Let me say that this way, because they have been humiliated, they have been ostracized, they have been discriminated, and then, so I will stop here. Thank you very much.
Yeah, thank you so much to all the panelists for your interventions. I would now like to open the floor to the audience for your questions. Please note that for the questions, we will only keep it to one question per person so that we can allow as wide as possible for everyone to, as many people as possible to participate. Please state your name and the institution that you come from and your question and the person to whom your question will be should answer. So the floor is open. Anybody with questions?
Hello, everyone. My name is Millicent Mudiwa. I'm coming from the United States International University, Africa. My question is going to the prosecutor, Mr. Sage Barnett, as well as to Mr. Michael. My question is, in the quest to gain accountability and to work hand in hand with bringing stability in the nation of Sudan, how can transitional justice processes effectively address the needs and concerns of marginalized and vulnerable groups, such as women, children, and minorities, who may have been disproportionately affected by the conflict and the human rights abuses currently going on in Sudan? Thank you.
Thank you. Hi, my name is Theola Rooney, and I'm also a representative of the United States International University of Africa. My question is for Christopher Gitari. You spoke about the second phase of transitional justice and the third phase, and my question is, what do we do about people who are perhaps still stuck in the second phase? And I get the sense that there's sort of a competition between the two. So how do you merge the importance of truth commissions and local justice with the importance of the international criminal justice system? Thank you.
My name is Doreen Reatieno, and I represent Riara University. And my question is directed to the panelists, but most precise to Michael. There is a statement that Michael said that really has stayed with me. He said that there is no justice without retribution and without repair. And about the concept of repair, it got me thinking, like, how can we link the concept of repair to the concept of transitional justice with regards to educating both the victims and the offenders? And also, are we offering psychological support to the victims? Could that be considered a form of resistance, like to offer them psychological support so that they could heal from the trauma they're experiencing?
Good morning. My name is Ryan Kamundia, also from Riara University. My question goes to Mikel and also partly to Saj. Mikel talked about working in Kenya, and we know the Kenyan experience and in the International Criminal Court. The current Minister of Defense, who was in government at that time, said that the United Kingdom government is the one which instigated those cases, which is why they collapsed, because they weren't strong enough. Went on to give an example that when he negotiated for a certain agreement, they decided to pull out the case. And there's that aspect in criminal law where everybody thinks that once a person is accused, they are guilty, especially if they are powerful. So as much as we talk about maybe people inside the country glorifying those people, we also have the possibility that we have external factors or external actors who are pushing these cases, and they may not actually be there. So how fair is the process to the people who are accused themselves, and is there a big aspect of international interference, especially when you're talking about third world countries?
Thank you. My name is Lynn Nyaga from ODPP. I have a question for specifically Serge and Mikkel on the role of asset recovery in transitional justice. I didn't hear any of the panelists mention this, so I'd like to know what exactly it entails. Thank you.
Hi, everyone. My name is Abdullah Hassan. I'm a researcher with Amnesty International covering Somalia and Sudan. My question is also going to Mikkel in relation to what we heard from Ahmed Goja, who said there is need to end impunity in Sudan, and impunity and lack of accountability for past violations in Darfur is what led us here. How do we reconcile between that concept of pushing for accountability for past violations and for recent violations, and the concept of no reparations, no justice?
Well, the first question was how to make sure that specific groups like women and children are getting the necessary attention. That's definitely one of the lessons learned also from the previous investigation commissions and definitely from all the international tribunals, that if you go for mass atrocity, the concentration in the early days is always on the murder cases, the most visible cases which are there, with the experience that in relation to sexual violence or violence against children is much more complex to investigate, is much more hidden in society. We have the problem, of course, of the stigmatization of the victims. And the solution for it is to make sure that in the early days of any accountability mechanism, any investigation, you make sure that specialized investigators, prosecutors are specifically working on this area. And this is definitely one of the areas to that, together with the Konrad Adenauer Foundation and other group of friends, we are organizing every 3 months, intensive training on conflict-related sexual violence investigations in East and West Africa, in Eastern Europe. So that's definitely one important approach. The second one is definitely one of the challenges, how to make sure that accountability mechanism domestically, is it now traditional justice, is it reconciliation, is it other local system are combined with effective international way of accountability. And I have the privilege of working at international tribunals for the last 20 years, and I remember very often when we have new lawyers, especially from the Western world, coming to join our tribunal, I'm always starting by saying, well, I need 20% or let's say 50% free space in your brain, because you have to learn that what you thought is the solution for a problem is probably not the solution applicable in a specific situation. And I have learned my time at the ICC dealing with Uganda, definitely in the former Yugoslavia when I meet with survivors, but also in Rwanda, that the traditional accountability mechanism, meaning crimes against humanity, war crimes, genocide, I think are universal and everyone wants to see them being respected. But if you really want to reach the local communities, you have to be very open for other mechanisms. And I took the example of Rwanda. You would never have had a kind of comprehensive approach if you had not had a combination between international, national, traditional justice, and then the gachachas. At the international tribunals, I would say that, we have all, at all international tribunal, there is within the registry a specific section dealing with defense counsels. Defense counsels which are paid by the UN or by the tribunal's budget if the accused had not the financial means to do so. So I would say, you speak with a defense lawyer, he probably will tell you that the prosecution has many more investigators at its disposal than the defense has, right? But I would say from my experience that at the international tribunals, definitely the right of the defense have always been or are, we try to have them very much respected, because, for a prosecutor, domestically or internationally, the worst is to have a weak defense. The worst is to have the impression not to be in a trial where there is equality of arms in relation to the trial. And that's why, as I said, I think that somehow it's easier to have the rights of defense guaranteed at international tribunals with international standards than very often in domestic systems, in particular if those who are allegedly responsible for the crimes committed are still in power, and that a defense lawyer being in this country having many more problems of speaking honestly and openly in a system where possibly he will be punished afterwards or discriminated afterwards professionally.
Okay, so I'll tackle the question first about the concept of repair with respect to perpetrators, forgiveness, and then there was also something about psychological support to victims, if this was also a form of reparations. If you heard what I said in the beginning about the concept of satisfaction, I think the notion of perpetrators coming forward sometimes after criminal trials, sometimes after truth commissions, and acknowledging their role in past atrocities can be a form of reparations. It can be symbolically very important to members of the affected community. We've seen that in a lot of different contexts. So I think I would say that indeed is a form of reparations. It also ticks on the box of reconciliation, which is a very key concept to, in my view, again, a holistic approach towards justice. With respect to psychological support, fundamental. It's under now the type called rehabilitation, and we know it almost without fail. These international atrocities result in psychological trauma. We are human, and when we are faced with this type of violence, it leaves a mark. Sometimes those marks can't be seen. And so psychological support in the wake of that violence is critical and a form of reparations. Now, one of the questions was about asset recovery. Thank you for asking. And I think this is also what Aishatu was talking about with respect to not waiting for the conclusion of international criminal trials that may take years before you start taking proactive steps with respect to reparations. It's just a no-brainer. I mean, if you wait, and this goes beyond even asset recovery, it's also about collecting evidence for the purposes of establishing reparation claims. These things do not need to wait. And I think even my colleagues from the prosecution can agree that it's not prejudicial this is what we do in the domestic setting, right? If there is a risk of fear of accused individuals hiding assets during this process, then those assets are frozen. They're traced, they're frozen, and if these processes result, whether they be criminal processes or civil processes or whatever they may be, those assets can then be used for future reparations in the form of compensation for affected communities.
Yeah, the question of my colleague in relation to asset recovery. Just want to mention that in relation to fugitives, for example, we have successfully seized assets in several European countries and African countries in relation to bank accounts, but also in relation to real estate, which was frozen many years ago and which we hope will one day be able to be used for reparation as well. So what is important that the freezing takes place very, very early before a fugitive or a potential convicted individual can have this money or this property disappearing.
One more. Yeah. So the last question that I'll address was whether or not there was tension between what my colleague Guja said with respect to these cycles of violence and the need to address impunity and the concept of reparations as justice. I think Guja and I are very much on the same page on this, that while, again, accountability in the form of retributive justice, so people being held to account if they're found guilty, put in jail, is very important to the concept of justice, don't get me wrong. But in this context, in the context of Darfur, which my colleague Guja was speaking about, if these other forms of justice were also carried out in the wake of this 2003 violence, so I mean in particular that the affected community was returned home, right? So they reestablished themselves. There was a disarming of local militias. There were guarantees of non-repetition. How much more difficult would this conflict be in Darfur? It would be much harder, right? It's much easier when none of these things have taken place. For these, there was no accountability. There was no skin in the game from the affected from the perpetrator community. They got away with it, is what my colleague was saying. So why not do it again?
Christopher?
Yeah, thank you for your question. I think there was a question about getting stuck in the second phase or third phase of transitional justice, and I think I was just trying to draw out general global trends in terms of what we are seeing, TJ, and how it's evolving. But I think the best way to answer the question is that what we've learned is that, one of the speakers, I think, is Aishatu, who said it, context-specific processes is what really is important. What the context tells us, and how when we are in a context, we will always see that certain processes are prioritized over others. And we say transitional justice, just like politics, is the art of the possible. So we're in a context, and in that context, you see that truth commissions are possible, and that criminal trials are not being prioritized, whether because of the politics or because there's actually ongoing war. So that context then defines us. And as practitioners, sometimes we say, when you do TJ, it's like an icebreaker that hits an iceberg. And when it does that, the cracks emerge on the iceberg, and they go in different directions. And therefore, your next hit will be where there's a crack, and you hammer it again, and it cracks some more. And that's what TJ sometimes is about, is looking at what is possible in a context, bearing in mind the goals of the country and the priorities of the victims. And as somebody said, one of the lessons learned in Cote d'Ivoire is urgent interim reparations, because really it makes little sense to pursue transitional justice for 20, 30 years in a very academic way, and yet victims have real needs. So it's really an idea, a call back to humanity, this bottom up, trying to see what is possible for the victims. And so again, I say it's the context-specific nature that leads us there. And then we go to the second one, which is sequencing and balancing, where we say, if there are a number of approaches that are possible, how do we sequence them, and how do we ensure that they reinforce each other? So in South Sudan, for example, there's a conversation about having a truth commission and a reparations authority. And the question, therefore, is, both can be done simultaneously. But does it make sense for the Truth Commission to go around and collect vehicles of victims? And then at the same time, a reparations authority does the same thing. Is it not better for the Truth Commission to register? And as it registers victims and receives the applications, can recommend urgent interim reparations, and then the CRA can come in based on the recommendations of the CTRH or the Truth Commission, and then begin doing that. So that is sequencing, and that trying to balance and reinforcing each other so that we don't have overlaps. And I think that's some of the idea of sequencing and balancing. And I think maybe we can carry on the conversation further. I think there is a question of just want to touch the question of the asset recovery. I think you can look at the Philippines. One of my colleagues, when I was at ICTJ, Ruben Carranza, went after the Marcos, who was the dictatorship before, and recovered money from the Marcos. And that money was used in the reparations programs in the Philippines. And I think that's an example of and above the ones that you've mentioned. Thank you.
Thank you. Thank you so much. So we'll take the next round of questions, and I'd like to quickly throw in my own question before the rest of you do. So My question goes to Serge. You had talked about the experience of the ICTY and how many of the accused persons have become national heroes. The whole concept of reconciliation is, it's still very difficult in the former Yugoslavia. So with what you know now, what are some of the things that the international community should have done? What should we have done differently? So I now start with, there was the gentleman here.
Hello, good morning. I'm Mordecai Oyugi, a representative of the Law Society of Kenya. So I had a question to Mikel. Just a question which has been disturbing my mind. Reparation. And then the concept of reparation, and I was of the opinion that if retribution is not enough, then how best can reparation be done to ensure that the victims feel that they have achieved justice? For the instance, when there are other damages which can be caused to the victims, but even retribution itself cannot make them feel that they have achieved justice. Thank you.
Thanks.
I wanted to ask a question about reparations too, and how to convince not justice actors, but political actors in particular that reparations matter. So, for example, we had the trial of Hissène Habré in Senegal at the Extraordinary African Chambers, and the African Union promised to set up a trust fund for victims and to fund it with reparations. And it's been 6 or 7 years now, and not a cent has gone by. And some of the very victims who received trial justice at that court have now passed away, including one just this week. Now, I get that we can persuade each other as being lawyers, advocates, justice and accountability champions, etc., that reparations are necessary and that perhaps we should fund them through asset recovery. But at the same time, it seems like the 100 of reports from Amnesty International, Human Rights Watch, local human rights organizations in Senegal, Chad, etc., haven't been able to convince the African Union to put really even just a paltry sum of money to give a small amount of reparations to victims of a trial that they helped set up. So I guess my question, perhaps this goes to Chris too, given your expertise on transitional justice. What language, what rhetoric, what persuasion, what types of persuasion can we use to convince these political actors to do what seems obvious, which is that victims and survivors deserve reparations? Thank you.
Okay.
My reflection, listening to all colleagues and friends, is about the question of sequencing, not as you put it, Chris, but sequencing peace and justice, because that happens quite a lot. Well, let's build peace and then we can think about justice, which never happens. And the issue of Darfur is a very good question. So today, listening to Aisha too in particular, but of course all colleagues, I'd like us to look at Sudan. So we have two conflicts today that we are grappling with. We've got the Ukraine, which is an invasion conflict, i.e. you have a country and you have a quote-quote declared enemy. But we have Sudan where the conflict drivers are internal. And taking the example brought to us by Aisha too, what can we realistically do today in Sudan to start a process? I know it's difficult because of the conflict, the insecurity, but unless we start reflecting together on what potentially we can think about, then we are going to be taken over by events and we'll say, oh, I wish we did it. And in doing that, I would like us to remember what Zainab was saying, which is basically the sense of ownership in relation to what Sudan would like to do with support by everybody else who would like to do it. So can we do something realistically today? Is my question. Thank you.
Thank you. Navi wanted to respond to Mark.
I absolutely must respond to Mark's question since he singled out the African Union. No member state of the United Nations will ever vote to pay reparations. So the United Nations does not pay reparations. The United States cannot be sued by victims. So it's all the member states, not just the AU. Of course, we, the civil society, continue to demand this, but we have to see how hopeless the situation is. Who's going to pay for reparation?
I think on the question of reparations is really forgotten that these processes are political. Where countries where they've been paid reparations, the victims are in parliament. They somehow got themselves elected. In Kenya, the farthest we went is because one of the members of parliament who was a champion for reparations sat in the budgetary committee, the late Koth, was a wonderful member of parliament, and a number of other MPs who had a close association and felt for the victims. Currently, Kenya is doing the Enderoy's case. There was an Enderoy's case which went to the African Commission, and it came back to Kenya, and Kenya government was told, you should ensure that they go back to the forests and get their land back. But why is the conversation happening? Well, because of a couple of people in government who were in the Enderoy's case. They were outside, and now they're inside. What I'm saying is that transitional justice is a political process. And so the hard truth is that it has to be political actors. And so whether civil society or victims have to organize and influence the politics inside and outside. And that's when we've seen successes when it comes to the issue of reparations. Of course, the other one is the real fear. When in Kenya we were discussing the reparations program, in very close conversations with people in Treasury, in state law office, they were saying, do you want me to be the one to pay this money in an administrative reparations program? And what if I make a mistake? Why don't you go to court? Because courts have immunity. So we have to think about reparations programs also having capabilities of giving them immunities. So they're able to give money and there will be no consequences. The real fear for government officials in setting up administrative programs, or that they'll feel that there will be consequences, there will be, and every context is different. Kenya, there's a lot of issues of corruption, scandals, and all that, which have been seen in other contexts. Even in South Sudan, we've seen where money is paid out and lost. So that was the difference. That there was a preference for you go to court, come with a court order, I'll pay. There's that, and then there's the idea of it's real hard, real politic, and so we need to think about TJ as that. It's not this soft thing. It's real politics. Thank you.
I take the one you ask. What could we have done better? A lot. I can speak hours about what ad hoc tribunals and all of us could have done much better. But in one word, I think the major problem in the former Yugoslavia is nationalism, because you had the conflict with several countries, and today being nationalistic, not only in the former Yugoslavia but also in other parts of the world, pays very well in elections. Which brings me to education, because one of the main problems is, for example, in Bosnia-Herzegovina, you have three different history books are used officially in schools, depending if you are from Republika Srpska, if you are the Bosnian community or the Croatian community. You have the Minister of Education in Republika Srpska, a country who wants to join the European Union, who has officially banned all reference, for example, to the siege of Sarajevo or the genocide in Srebrenica out of the history books by saying this never happened. So nationalism is definitely one big problem. Second, it has been said before, justice is best served if it is served domestically, in a language which is understood, in a legal system which is understood. So it's relatively easy if you see those very long proceedings in The Hague, a common law system mainly, where many of the countries have more the civil law system, not understanding necessarily what is happening, legally very complicated, judgments which are 1,000 pages long, which is difficult to communicate. So definitely outreach, communication, explaining much better what is happening. But as I said, we have showed in the courtroom videos where soldiers under the orders of General Mladic were executing prisoners. It was showed many times again and again, and still he's considered as a national hero. And last point, irresponsible politicians. You have still a lot of politicians in power or again in power in the former Yugoslavia who were in one way or another supporting groups within the conflict and who today are trying to hide their failure in economic areas, in other areas, by still playing this nationalistic card in order to be re-elected. That's the unfortunate reality. We had it when we were looking for the arrest of fugitives. And in some countries, when their surveys were made, a majority of country were of people in the country were against the arrest of the fugitive. And it was only once surveys were done. What is more important, so which percentage in Serbia is in favor of joining the European Union? Was 75%. Which percentage is in favor of not arresting the remaining fugitives? 60%. And it's only if the political agenda and the political objective for politicians is higher by cooperating that they would not act in a very nationalistic way. Thank you.
Okay, thank you. I want to react to what Fatiha and Nabi said. What can we do today to support Sudan? Because it is true, any transitional justice process should, it is what is would be the best, should start at the root of the conflict. But it is also true that the Sudanese are the ones who have to say where they want to go. I don't have the answer, to tell you the truth, but I think it could be a kind of discussion, thinking, and then how they can express the diaspora and the people back in Sudan, how they can express their will, and how international community can support them. It must be discussions. So I want to also react on this issue of irresponsible politicians. Why in Sudan, 20 years, since 20 years, never ever we still not got reparation or trials against perpetrators? It is because the people sitting in power were the ones who were supporting the militias. They were protecting them. It is the reason. On the difference of Côte d'Ivoire, where the people who organized, who were the supposed perpetrators, they were kicked off the power. And other people came to power. And those people were responsible enough to say that we have to rebuild the society and then to work to reconciliation. That's the difference. And still, if nothing changed in Sudan, in 20 years again, the situation will remain the same. It is the reason I was saying that if you do not have a credible state, you cannot think about bringing people to justice, even to ICC. I think that the country should accept to send you people. And if in the case of Sudan, al-Bashir never ever went there. Thank you. Oh yes, what Nabi said, the last comment, it is true. There is a policy in the United Nations. They won't pay reparation. They do not want to pay reparation. So how do you want to hold accountable any state because of not giving reparation? Côte d'Ivoire is a very strong and wealthy country, so they decided to do it by themselves, which is not the case of everyone. Thank you.
Just want to address this question about if retribution is not enough, what can reparations do to give victims a sense of justice? Just to take a step back, because it's not always that retribution is not enough. And I think some of my colleagues have talked about with respect to how important it is to have a victim-centered approach. Sounds a bit jargony, but it's true. And the point is consultation is critical. And if you speak to somebody and you find out what justice means for them, it may be a lot different than someone else. I'll give you an example. I worked in a disappearance case in Nepal. We were submitting a case before the Human Rights Committee. And while accountability and retribution was important to these villagers, the most important thing was identifying and locating the remains of their loved ones. Because in their traditional society, if they don't identify the remains of the loved ones, they were considered cursed and banished from the village. And banishment from the village was a death sentence because they couldn't feed their families. This was the #1 concern. I worked in Ituri, in Congo, dealing with the Hema and the Lendu. Nobody on the reparation side wanted to hear about what these guys had in mind with respect to reparations. There is a conceit. I heard someone talk about bias against the global south. I would argue that the stronger bias is between elites and non-elites. This idea that you just know what these people are going to ask for, and you don't need to ask, right? I sat down, luckily we had a very enlightened chamber in the Katanga case, and they ordered my office, and me in particular. I spent 4 months in Eastern Congo doing nothing but consultation on the concept of reparations. Things that came out of that consultation changed my life and changed my professional career. The things that have been tried on these people without consultation. We're not going to give you cows anymore because cows are the source of the conflict. We'll give you a fishing net to share instead. We'll give you a sewing machine instead because we just know better. And this is the modern economy. And you just need to get in line. And when you speak to these people, they say, but in my culture, without a cow, I'm not a man. Without a cow, I can't get married. So if you give me a sewing machine, I'm going to sell it and buy a cow. If you give me a fishing net, I'm going to sell that or catch fish only to buy cows because I'm going to reinstall and re-envisage my life the way it was. And I don't care about your priorities. Consultation is key. Now going to the point of Navi and Mark, reparations are not always resource drivers. We can be creative. We also have to think about these things. It's hard. It's a hard concept, but we shouldn't be afraid of hard things. Yeah? In the context of Sudan, these guys want to go home. They want to leave these camps and return home. And it's one of the few situations I've worked on in my career where there's not actually people sitting on the land. There's an opportunity here. Does it require millions of dollars from the United Nations? It doesn't. It requires some political thinking. It requires some advocacy. It requires security. It requires a number of different things. But these aren't all necessarily resource drivers. We don't have to always think about reparations as malipo, as I said in the beginning. It's not always just compensation. And when victim communities understand that compensation may not be a political reality, you'd be shocked to hear how creative they can be about things that will help them get their lives back online that may actually be political realities. Let's not be afraid of the hard things.
I would like to add one very quickly
Okay.
add very quickly to give an example of this necessity to be creative. We worked on, I was co-chairing the WHO Independent Commission last year with regard to SEA in DRC, in Congo. So one of the victims said she was a young lady who was studying. So she got abused, she got pregnant, and she said the only thing she needs is assistance to go back to school. Yes. Do you know that they said that UN, United Nations, is not providing anything? In this case, they should have been creative to find the way to assist the young lady to go back to school. That is what I wanted to add.
Thank you so much. And I think Michael's last words are the most important words. Let's not be afraid of the hard things. Let's not be afraid of thinking. Let's think about solutions.